Hi, good afternoon. Today is Wednesday, January 17th, 2024. My name is Ashley Glover, and I'm here with Kim Christian, and we are happy to welcome you to our webinar, New Year's Resolutions, Plan for Success. So let's kick things off as we usually do with a few housekeeping items. This presentation is scheduled for 30 minutes. We put together a PowerPoint, which we are showing on screen along with our webcams. To help minimize background noises, your mics are muted, so you'll want to use the Q&A box to submit any questions. We've saved time at the end to answer as many as we can. Feel free to message other attendees in the chat box. We are recording and we'll email you a link to the recording. And finally, we value your feedback, so please let us know how we did in the webinar survey. That survey will appear on your screen once the webinar ends. Now I'd like to introduce today's presenter, attorney Kim Christian. Kim is a dedicated partner with Russo Law Group. She's the lead planning attorney in our Lido Beach office. She also meets clients in our Garden City office virtually, and she makes home visits. She's been with the firm for over 15 years, helping clients with elder law, Medicaid, special needs, estate and trust planning. And finally, Kim was recently recognized by Lawyers of Distinction for her excellence in the practice of law. So, Kim, thank you so much for being here. Could not do this without you today. So I'm going to hand it over to you.
Thanks, Ashley. So glad to be here. I am particularly excited because this is the first webinar for the new year, so in 2024. So welcome to those who have joined me on one of our firsts. I love it. I'm very excited. So what we'll cover today, we're going to talk about decision-making documents, protecting your assets if you need long-term care, and how to leave assets to family in a secure way. This ties right into New Year's resolutions, because if you're anything like me, when I start to think about the new year, I just want to clean my house. I want to make sure I have things done that I need to get done, and estate planning is one of those things. So we thought we'd start with some fun. For 2024, the top 3 New Year's resolutions were to improve fitness, improve finance, and of course, improve mental health, right? So top 3 2024, fitness, finance, and mental health. We also thought this was neat. We broke it down actually into ages and stages. So for preschoolers, the top few resolutions were to clean up their toys, brush their teeth, wash their hands, eat their vegetables, and be friendly to animals. Then we moved up to the elementary and middle schoolers. So drink water, make sure they wear that seatbelt, be more active, care for skin, and I think this is a really important one, talk out some problems if they have them. New Year's resolutions for teenagers: help the community, help manage stress, ask for help if they need it, and help others. Bullying is a big issue, so one of the resolutions is to stop that bullying. Centenarians, right? New Year's resolutions for that age and stage. I want to see more of the world. So traveling around the world is one of the big resolutions. I think that's a good one. I want to make a difference. I want to get a new bachelor pad. So some people are moving, and I want to keep winning at poker, playing those games, keeping active. So for me, or for this law firm, we believe strongly that one of your resolutions should be getting your estate planning in place. So we came up with this Secure My Future list, and I think it's a really good one. If you take a look at this list, this will help with your resolutions and what you should be thinking about. It's an organizational tool. So you want to update your will if you need to. You want to update your advanced directives if you need to, or make sure you have those in place. And I'm going to talk about more specifically what those entail. It's good to map out your family tree. You should have what I call the family conversation or crucial conversations. That's a conversation that you have with your immediate family or those who are helping you or part of your estate plan to say, hey, this is what our intention is. This is what we're doing. Do you have any questions? All right. This is what we plan. The asset and access list, that's huge. Even with passwords, right? Like, or the digital diary, I call it. Probate avoidance. How do I avoid probate? We all know that question. How do I protect my assets if I need long-term care, asset protection? And then I love the picture we have here. It's of a house. How do I make sure the foundation of that house is in place? I just want to make sure my estate plan is up to date. So let's start off with what I call the foundation, the absolute must-have legal documents. If someone said to me, Kim, where do I start? How do I make sure my estate plan, the foundation of it is sound? And I'd say, listen, you got to have the must-have legal documents. Those consist of your durable power of attorney, your healthcare directives, which consist of a healthcare proxy, a living will, and a medical authorization, also known as HIPAA, and a last will and testament and/or living trust. So let's start with decision-making documents. First is the power of attorney. The power of attorney is for financial decision-making. It takes no power away from you, but it says in the event I need or want someone to make financial decisions for me, who are going to make those decisions? That is so important. If you cannot make your own decision, who's going to pay your bills? Who's going to consult with your accountant, file your taxes, do all the things that financial decision making entails? So if you look at the bottom of my flow chart, you can see it involves bank accounts, brokerage accounts, real estate, your income such as Social Security and pension, your house, discussing things with your estate planning attorney, discussing things as far as taxes are concerned, anything financial. This is one of the most important documents because if you do lose capacity, your ability to make your own decisions, then a loved one has to file for guardianship for you. If you just have the power of attorney in place, that will avoid the need for a guardianship. So, so important. Your healthcare proxy, that's also a very important document. Your healthcare proxy is for healthcare decisions. Who has the right to make those healthcare decisions for you if you can't make your own? So the doctors will always ask you first, what do you want as far as your own healthcare decisions? But in the event you're in a situation where you can't answer for yourself, the healthcare proxy designates the agent that is going to step in your shoes and make those healthcare decisions for you. There's a primary agent, and then you can also have successor agents, people who are backups to your primary. And it's effective if you lack the capacity to make your own decision. You can make it very personal. You can decide, do you want to do organ donation or not do organ donation? You can add information about artificial nutrition and hydration. The point is you are nominating a voice, a person that you trust to step in your shoes and make your healthcare decisions for you. From the smallest healthcare decision all the way to the largest end of life decision making. Living will. This is also very personal and very important. This has to do with end of life decision making, life sustaining treatments. You have the right to make your own decisions, but if you can't, this is your instructions as to the withdrawal or the withholding of extraordinary life sustaining treatments. You can have triggering events. You can say, if I'm in a permanent, persistent vegetative state, there's no chance of recovery. 2 doctors agree. I can no longer experience a meaningful life, right? You can put in writing, if I'm ever there, please do not keep me alive by extraordinary means. You can say, I'd like pain medication, pain relief medication as well. So this is a very personal document. You want to make sure it's tailored to your thoughts and feelings and what you believe. But it's important for two reasons. Number one, for legal reasons. You want to make sure you have this down in case there's ever a question mark as to what you want. And number two, for personal reasons. If your healthcare proxy is carrying out this decision, it may give them the support and the comfort to know that this was your wish and direction, not necessarily their instruction. So we just talked about this. You just ask yourself, would you want extraordinary life support if you have no chance of recovery? Here in New York, the law presumes that you want life-sustaining treatment unless there is what's called clear and convincing evidence as to your desires. The living will does meet that evidence. All right, so before we move on to our next category, I just want to re-go over what I would call part of the foundation of our plan. So we want to make sure we have that power of attorney for financial decisions, the healthcare proxy for healthcare decisions, the living will for end of life decision making. And of course, along with the healthcare proxy, you want to have an embedded HIPAA authorization. That way your healthcare agent is not barred by any confidentiality rules and they can make decisions and not operate in a vacuum. All right, so let's move now to protecting your assets if you need long-term care. It's really important. A lot of people come to me and they say, listen, one of my New Year's objectives or one of my New Year's resolutions is that if I ever need long-term care, I want to make sure I can get it covered without losing all the assets, including my home that I've worked so hard for. So you may need Medicaid home care or nursing home care, and you don't want to lose all your assets. You may own a house that you want to protect. You may know someone else who feels that way as well. It is a very, very common objective, but it's so important. So how is long-term care paid for? Well, long-term care here in our area is so costly, right? A nursing home, the average is running about $15,000 to $16,000 per month. Home care is not far behind. If you need 24 hours a day, 7 days a week, at $30 an hour, you are really expending a lot of money per month if you do not have the means to do it. So the three ways long-term care is paid for is privately. Some people may have what's called a long-term care insurance policy. That's a policy that covers your care on a daily basis in the event you need that long-term care. But for those who cannot or do not want to pay privately or don't have long-term care insurance, they may look for Medicaid to cover them. So, in order to become eligible for Medicaid, you've just got to make sure you get the proper planning in place. What this comes down to, and it's so important, is planning in advance. Because if you can plan in advance and you can say to yourself, hey, I may need long-term care in the future, let me start this now, then you really have the ability to protect your assets. You can protect your home. You can protect other homes that you have. If you have vacation homes, you can protect some of your liquid assets. And then what that will do, once you do that asset protection planning, is it will allow you to access the Medicaid system to cover your care at home or cover your care in a nursing home. The key to nursing home care, though, and you may have heard this, is getting past that 5-year wait. It's called the 5-year look back. So my point in bringing this up is do this planning as soon as possible so we can make sure we protect your assets and put you in a position to get the long-term care that you need. So what would I use to protect my assets? Some people say, Kim, what's the most common legal vehicle that people use to protect their home or to protect their liquid and to make sure that they put themselves in a position to get the care they need? And I typically or often will recommend something called a Medicaid Asset Protection Trust. That is a separate entity that you will set up, and it allows you in some instances to keep your income if you want it. There's no additional income taxes. You can report it on your own personal income tax return, and it protects your assets so it goes to your heirs. It minimizes taxes on the sale of the residence. It provides flexibility. It avoids probate. And it most importantly, or as importantly, I shouldn't say most importantly, as importantly, it protects the assets from Medicaid and the nursing home. So let me give you an example. If my home, the deed to it reads Kim Christian, and I change the ownership to my Medicaid Asset Protection Trust, perhaps my deed now reads the Christian Family Trust, then I have protected that asset in the event I need long-term care for nursing home after a period of 5 years, for home care immediately. And I have the comfort of knowing that, hey, wait a minute, my house, my security is protected. So please consider Medicaid asset protection planning if you feel that you might need long-term care in the future. So we covered taking proactive steps to make sure you secure your assets in the event you need long-term care. But there's another piece to this puzzle. That puzzle piece is very important while you're alive, right? Because you're going to may need that care, and you want to make sure your assets are protected. But we also want to make sure that we leave assets to our beneficiaries in a very secure way. So what do I mean by that? So sometimes people want to protect their children from creditors or marital problems. They want to ensure assets pass to family with little or no delay or difficulty, or they want to protect a child with special needs. These are just some examples of the things or the objectives that people are looking to accomplish. I can tell you statistically that many people are concerned about their children, and what if they get a divorce? Or what if they have a creditor? What if they're not good with money? Or what if they're on a means-tested program that has life-saving measures for them? Or programs for a child with special needs? You certainly do not want to leave assets outright that may disrupt or hurt them in any way. And then the middle slide, ensure assets pass to family with little or no delay or difficulty. A tremendous, tremendous objective. It's very important. Sometimes probate, as we know, can result in a very lengthy delay in getting assets to those assets to pay bills or whatever the case is. So you really want to think about structuring your estate in a way so that there is no delay or difficulty. So how do we do that? Well, number one, you want to make sure, and this is part of our foundation of our house, right? This is the must-have legal document. You want to make sure you have a last will and testament, because that last will and testament is a roadmap as to what you want to have happen to your assets when you're no longer here. It's also a roadmap of who you want to carry that out, also known as your executor. And then what you're going to do is you're going to build on that. And you're going to create a revocable or an irrevocable trust. That will help avoid probate. And within those documents, you are able to say, I want a supplemental needs trust for the person I'm leaving assets to who is on a means-tested program. I want a secure spendthrift trust for the beneficiary who has spending issues or other substance abuse issues or marital issues. I want to create a trust so that I know that there is a seed for my child in the future, right? There's so many different reasons, but it can all be accomplished if you leave your assets in a secure way, right? So you can have the terms provide that there's a special needs trust or a supplemental needs trust, or what we call a family protection trust, right? That's for marital issues, creditor issues, things of that nature. So what's really important is when you're doing your New Year's refresh, you're coming into us for your estate planning, you're talking about everything that's going on. This is what I'm concerned about, Kim. This is what I want to protect against, Kim. There is no topic that is off limits because the more your planner knows, the more they can help you navigate the future. So the question is, when and why should I update my existing plan? Well, the rule of thumb is that you should update it every 3 to 5 years or upon the occurrence of you getting remarried, someone in your family or one of your beneficiaries is getting married, you had a new child, or someone who you're leaving assets to had a new child, there was a divorce, whether it be you or someone in your estate plan, a major change in assets, up or down, doesn't matter. We need to talk about it. Retirement. Hey, I'm going to retire. I need a projection. I need to understand what I'm going to do, right? We should talk about that. A health diagnosis, that certainly is what we would call an indicator of why you want to make your estate planning in order. Or the death of a loved one. Perhaps someone in your estate plan passed away, or perhaps someone else passed away, and you're about to inherit assets. So even if you don't have any of the indicators on this list, I feel very strongly, and this is part of my New Year's resolution, make sure your documents, if you've done them already, do what they say, right? And mean what you want them to say. And that's where the 3 to 5 year checkup comes into play. We go to our doctors for a checkup. We should be going to our estate planning attorneys for a checkup, because I will share with you, when I open the documents and I review them with most of my clients, I can see, hey, the executor is no longer with us anymore. We should be updating that, right? Or, you know what? My child just got married. I want to make sure I leave assets in a secure way. Or, you know what? One of my kids moved back home, and I want to make sure I make a provision in there so that if I pass away, they can still live there and they're not forced out, right? So there's so many different reasons you just want to be dusting that off, making that review, finding out, hey, is my existing trust revocable or irrevocable? Asking those questions, being very clear. This checkup also includes your long-term care insurance, the review of the policy. Yes, we want to find out if your documents say what they say and do what you want, but we want to make sure your long-term care insurance policy does that as well. So there's so many different reasons why you want to update your existing estate plan. And for me personally, January 1st, I revisited mine and I realized, hey, there's some tweaks I have to make. My children are a little bit older. There's things that are going on. There's new players in our world. So I'm encouraging all of you, as part of your resolution, to update your estate plan. And if you don't have one, certainly implement it. So let me do a quick recap, because we're almost out of time. And I want to say, make sure that you have your foundation in place. Your power of attorney is for financial decision making. It takes no power away from you, but in the event you need or want someone to make financial decisions for you, these are the people that are going to do it. Your healthcare proxy is for healthcare decisions. Doctors will always ask you first what you want, but in the event you cannot make your own healthcare decision, who's going to make those decisions for you? Make sure it's someone that you trust to carry out what you want to do. You're going to make sure you have a HIPAA authorization. That way your proxy is making decisions with the most amount of information possible, and they are not barred by any confidentiality rules. You want to make sure you have your living will in place. As I mentioned earlier, there's 2 reasons for that, both legal and personal, and that is your instructions as to end of life decisions. Do I want to be kept alive by extraordinary means in certain circumstances? We then move into the world of asset protection and smooth asset disposition. So you really want to consider protecting your assets in the event you need long-term care. As we know, the cost of care in our area is very expensive. So if we set up an asset protection trust, for example, we can make sure we secure our assets so that if we need that long-term care, we can get covered by alternate means instead of having to spend down our assets or having a lien put on our house. So, so important. Lastly, we just want to make sure that we avoid probate, right? And we can do that by setting up a revocable trust or an irrevocable trust. And we just want to make sure that we have that in place. We also just want to make sure we leave our assets to our beneficiaries in a very secure way, whether it be because we're protecting someone who has special needs and we do not want to disrupt their benefits or bar them from getting any sort of benefits, or we're concerned about creditor issues, we're concerned about marital issues, or any sort of triggering event that concerns you. So what do you have to do? You got to create the plan. And we can help you with that. When you come in and you meet with us, we sit with you, I review all of your information, and it's tailored to you so that you can create that plan. You got to make sure your legal documents are comprehensive and up to date. And then New Year's resolution, you have to do it. We got to get our plan implemented. So we're happy to help. Next slide, Ash. So this is a thank you for attending. And typically our planning meetings are $600 because at that meeting, we give you valuable information, guidance, and we come up with that plan for you. But it's going to be at a discounted fee of $400. We're going to take $200 off because we appreciate so much taking your time. So bring this coupon with you or just mention the code New Year when scheduling that appointment. Questions? And I think we do have a question, so I'm happy to answer them. Is a home during your lifetime exempt from creditors? No, the answer is it's not. And it really depends on what creditors you're talking about. But let me give you a couple examples. So if I am talking about long-term care and I need to get Medicaid, many of my clients come to me and they say, I heard the house was exempt and I could go on Medicaid with the house in my name. And in some instances, that's correct. It is exempt. You can go on Medicaid with a house in your name. But when you pass away, they will get paid back from that house and place a lien on it. So if that is your question, it is never good practice to leave the house in a person's name that is going on to Medicaid unless there is a specific reason. We know there's exceptions to every rule, right? And this is a very general seminar. This is not legal advice, but please be mindful of the nuances in the law and don't think that houses are exempt from creditors during lifetime. Same with regular liens. If you have a home lien or a tax lien or something's going on, they absolutely can attach that to your home. So please be mindful of that. I hope that answers your question. If you are concerned about creditors, please bring it to our attention. Any other questions? Okay.
Okay, I'm not seeing any more of the live questions. We'll go ahead and start wrapping up. What makes Russo Law Group different? So our clients tell us that it's our dedication, accessibility, scope of legal services, and years of experience that gives them the peace of mind and confidence when working with us. Russo Law Group is a boutique firm focusing on areas of elder law, special needs, estate planning, and estate administration since 1985. We have 3 convenient office locations in Nassau and Suffolk counties. Our firm has 11 attorneys, and we stand ready, willing, and able to step right in and help. We've helped over 17,000 families, and we ranked as a best law firm in the area of elder law by US News. Finally, a list of the services that we provide and how we can help you and your family. We have a robust website at vjrussolaw.com We offer terrific information, forms, checklists, resources, so take advantage of it. There's a complimentary guide on estate planning. I will actually go ahead and drop a link to that in our chat box. Just give me one moment. Okay, and it's complimentary, so you can jump in there and go ahead and download your guides. As a reminder, please leave us your feedback in the post-webinar survey that will appear on your screen momentarily. And in case you missed any portion of today's webinar, we will email you a link. So, Kim, thanks as always. A wonderful job. I hope everyone stays well, and we'll see you next time.
Thank you for joining us.
Bye.
Have a great day.